Yes, welcome to the No State Project here live from my YouTube channel. No State Project live from the fortified compound in Mesa, Arizona. I do have to apologize, although it's not the important part of the show, for the video. But major tech problems with my main with the computer I normally do the show on, and it's just nothing I can do about it right now. It's a tech issue that is far beyond my pay grade. I'm gonna have to do the old what do you call that? Some YouTube tutorials to try to figure out what the hell is going on with that computer, that the Windows. This is a bit older of a Mac, works flawlessly, other than it's old and I don't have the processing power to do, really good HD video. So if it is a little choppy, not a big deal. It's not why we're here. We're here to talk about the, anarchy, get into a voluntary governmentless society, government abuse, and defending yourself in court. So everybody knows what I look like already. So that's not the main part. So I am going to take calls. Give the number right here in a second. I want to thank everybody again. Appreciate the continued support of the show. Always needed. I never seem to quite make everything, but I do appreciate what we get. If you want to help support the show, it's Marc Stevens at marcstevens.cells.com. It's in the description. Also marcstevens.net. If you're being attacked by a bureaucrat and you want to learn how to effectively defend yourself, no guarantee that you're going to be able to replicate the results that I and hundreds and hundreds of other people have had, which we have the documentation at marcstevens.net. But you can get that help at my website. We have templates for motions to dismiss, scripts to help you understand the process better on how to confront somebody who is making a claim against you. And Government Indicted, of course, the book has a complete model on how I go about doing things, and even that was based on the success we had with Adventures in Legal Land, which was replicated all over the United States, of course, Canada, Australia, New Zealand, and England. And so update and do more information in Government Indicted, a bit more explicit on how to defend yourself against these people. And we've been able to, for more than 5 years now, continue replicating the success that I reported in Government Indicted. So again, it's marcstevens.net. The number to the big show over here today, 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign, and, or the hashtag. And what's interesting though is, unlike the Windows machine, yeah, I'm looking right at you. Unlike that Windows machine, I can do my callers all with the same computer like I used to do. I didn't have to set up, and have the mixer be between the two computers so that the Mac plays has the callers, and then that goes through the mixer, and that goes into the Windows machine. To the Windows machine, I don't know what the hell is wrong. I don't know. I don't know. There's gonna be a Linux guy that's probably gonna tell me that you're wrong on both counts. So, Stahl is saying, yeah, Marc has the pyramid on his t-shirt. He must be a Mason. So, yeah. Do I have a pyramid on there? Or is it, well, it's the Trooper. So, anyhow, I don't know. Maybe somebody can explain to me what it is with the Windows machine as opposed to the Mac. Although, for some reason, there is a very, very low buzzing that I will be able to remove, on Audacity when I post this tomorrow. So, I'm sure no one's going to be too broken up that this particular video is not going to, stay up on YouTube. So we'll be pulled down tomorrow. So, but if anyone can explain why is it that on the Mac I can run the audio through, from Skype, I can run it through the mixer and onto the air, like when I'm doing this or when I'm doing the LRN broadcast on Saturday, which I will not be live this Saturday. I gotta go back to California. But, why is it I can do it on the Mac, but I can't do it on the Windows? On the Windows, there is a unbelievably loud, static. And there's no way that and I've worked with some people, there's no way to remove it, which is why I always use the two computers when I do the show, typically, but for whatever reason. Alright. Number of things to get here today before we start getting to the calls. Wow, we've already started lining up, but I've got to get this done, so I'm going to beg some indulgence, some patience there, because a few things have to come out. I have to do some little minor edits on a call of shame. Well, it's not necessarily, it's not exactly a call of shame, but it is, we have someone that I'm working with in Mississippi, which, gotta tell you, very few people, I've worked with I've got orders and worked with less than 10 people from Mississippi since 1997. So Mississippi doesn't come up, but this is good because, again, it's not too often at all we get Mississippi, but boy, when I got something from Mississippi, now I'm gonna get the recording, but I do have to do some minor edits because I don't want somebody to possibly go to jail. I would hate for them to be held in contempt. He's already posted this, but I wouldn't post it without deleting the name. To protect the innocent there, and I don't mean the judge. Now, the judge was different than most of these people in that he was very professional, in that he was patient. And he said, now I see you've got your checklist there, and I want to give you the opportunity to ask your questions so that you do understand, the process, and that, you believe and trust that you'll get a fair disposition in the court. I was like, oh, okay. Contradicts himself in a huge way. Huge way. When he first asked if jurisdiction is an element of the charge, because this is criminal, traffic, that's still criminal. He initially said jurisdiction is always an element of a charge. Well, yeah, that's why these lying judges will say that jurisdiction, when you challenge jurisdiction, they'll say, oh, the jurisdiction is a trial issue. This gets better. So, when he starts asking him whether he is presumed innocent of that particular element, since he's already said he's presumed innocent of all the elements of the charge, and then he said, well, is jurisdiction an element of the charge? Yes. Well, so I'm presumed innocent of jurisdiction. So then the judge contradicts himself, and this is beautiful. This is a beautiful thing. Really beautiful. It warms my heart. He turns around and contradicts himself and says jurisdiction is not an element of the charge. But he redeems himself. He actually stated, and I've heard it twice, he states that jurisdiction is not an issue of law. He says jurisdiction is a factual issue. Yeah, no kidding. He actually, to try to support the prosecution here, he lets loose some truth. Well, first he says that jurisdiction is an element of the charge. So good on you for that. Then he admits that jurisdiction is not a pure issue of law. He admits that it is actually a factual issue. I guess to be technical, it's a mixed issue of law, in fact. But it is a legal conclusion or a legal determination or claim that must be based on evidence, facts. That's why the typical contradiction is, jurisdiction's a pure issue of law. It requires no evidence to prove it's true. We just have to show that you're physically here. Well, whether you're physically in Mississippi or not is a issue of fact. Now, whether that fact is sufficient to prove a written instrument from over 150 years ago applies to you and creates obligations, well, clearly your physical location is not evidence that a 150-year-old written instrument applies to you and creates obligations on you. So, this individual, this guy, he did pretty good. And to have them admit it's a factual issue, and then of course he went to the affidavit, the complaint that was filed by the cop. Well, it's alleged to have occurred right here in Mississippi. And instead of, the protocol, the tactic here is to take their general statements, their general allegations, and to ask leading questions to get them to be more specific. So a good follow-up here, which he didn't do unfortunately, but he goes to see the prosecutor tomorrow. So I'm hoping, that he's gonna give this prosecutor hell, which is easy to do if you're asking good leading questions. So a better follow-up, a more effective follow-up for this when they point to the ticket is, so the prosecution's argument is if I'm physically in Mississippi, then the laws apply and give jurisdiction. And they'll say, well, yeah, duh, that's what I've been trying to beat into your head there, son. Good. All right. So what facts prove that just because I'm physically in Mississippi, the Constitution, a written instrument, applies to me and creates obligation? Of course, there isn't any. And not only isn't there any evidence, it then follows there couldn't be a witness with personal first-hand knowledge of that. You can't have personal first-hand knowledge of evidence that doesn't exist. At least that's what my logic tells me. If somebody thinks different and they have a better argument, then 218-632-9399. And, I will get that posted. It's not very long. The part that I want, the real meat of it's only a few minutes long. So you'll hear him contradict himself. Jurisdiction isn't an element of the charge. And then when challenged on the presumption of that element of the charge, then it's not an element anymore. It's a factual element that he thinks is satisfied at this time at arraignment by a mere allegation. Okay. Now, some are probably going to go, well, there you go, Mark. That's meeting the statute. That's meeting the prima facie. Oh, he did it. You got it. Mark, you're admitting it. No, I just explained. Your physical location in no way, shape, or form is evidence proving that it's not evidence at all proving that a written instrument called the Constitution, that's a fact, not up for reasonable dispute. No evidence that this written instrument applies. Zero. And that's why they can't explain. That's why they have to just say it just does. It's magic. Mark, Odin spoke from the clouds. The laws are not just mere written instruments by ordinary men and women like you. No, they come from Odin himself. They're special. These are magical written instruments. Anyway, we'll look for that. I will get that posted as soon as I can. Because it's good. So good. Yeah, we've got a sitting judge admitting in plain English that jurisdiction is an issue of fact. Very nice. So, I don't expect that we're going to get a bunch of people pounding on their keyboard. Well, Mark, this is Mississippi. They're all idiots. They're all effing idiots in Mississippi. You can't go based on this one. I'm not. I'm just saying we got one that actually did some semblance of the truth. And again, before I move on, anybody who asserts that jurisdiction is not an issue of fact, that it's a pure issue of law, which means a pure issue of law is one of legal interpretation of what the law says. That's it. That's what legal interpretation is. So if the law states that murder is the taking of an innocent life with malice aforethought, okay, that's all it means. It doesn't mean anything else than that. It doesn't mean that you're excused from actually proving that X committed this. But I am working on this. This is quite a week this week for, I could do regular installments of, the rich and their privilege. And yes, I'm including politicians in that because politicians tend to be very, very wealthy, okay? And cops may not be wealthy in the sense that, Nancy Pelosi is. No, most cops are not multimillionaires. Of course, but they are carrying out the orders for the multimillionaires. good to be the king's men. They have a lot of dirt. They see a lot that they turn a blind eye to. This is not a matter of conspiracy theory either. We know that this is conspiracy fact. Because if we go just based on Judge Kaczynski from the Ninth Circuit, and he gave a lot of citations just to prove his point that prosecutorial misconduct is at epidemic levels in the United States. That is at least a Class 1 felony obstruction of justice. And you've got the judge and the prosecutor, and he said, the only reason why we have an epidemic is because of judges. It's not laid squarely on the shoulders of these prosecutors. He put the blame, mostly on the judges who allow them to get away with it. So let's not forget that. It's very common for these rich people and their henchmen to get away literally with murder, mass murder. You can bomb a school bus in Yemen. It's just brown people. It's poor brown people. Drop a bomb on a school in a rich part of town. You don't, and especially if they're really rich, bomb the school bus. Well, then again, the rich wouldn't be taking the school bus, but bomb someplace. Let's not talk more about that. The actual news, of course, is the Mueller report has not been released, but Mueller used to work underneath Bob Barr. That was his boss years ago. They're good friends. Bob Mueller is the one that was head of the FBI during the 9/11 years. So I'm not a fan of Bob Mueller. This Bill Barr is a fixer. He is a political fixer. He is the guy that worked behind the scenes and in the front of the scenes there as Attorney General to get a pardon for those Casper Weinberger, some very heavy hitters, get him pardoned for their part in the felonies committed during the Iran-Contra. Now, Reagan got to die without serving a day in prison for what he did. Not a single minute did he spend in jail for the crimes he committed, because the rich don't go to prison, especially if they are mega wealthy. Presidents, see, it reminds me of Kay saying to Michael, you know how naive you sound? Presidents and senators don't have people killed. Oh. Who's being naive now, Kay? It was no surprise that Sessions gets fired and they bring in the ringer. They bring in a guy who's known for getting politicians off scot-free. He wrote a 19-page memo over a year ago stating that the president can't obstruct justice. Oh my gosh. They hired a guy. This is what gets me. It is so transparent. It is so in your face obvious, but they can get away with that, to borrow a phrase from Ernest Hancock. Why do they get away with it? Why do they do it? Because they can. There is no responsibility. There is no accountability. So of course, he does a 4-page summary of hundreds of pages of a report. Of course he doesn't see obstruction, because the president, in his opinion, cannot obstruct. Oh, shades of Richard Nixon.
Well, when the president does it, it is not illegal.
The unitary executive. All that crap. Remember from the Bush years? And guess who? One of Bush's big attorneys to defend all the crap that Bush did. He's now sitting on the Supreme Court. Yeah. They don't get held accountable. That's why when Trump said he could shoot somebody on Fifth Avenue and not lose support, because he was right. Because people of in his strata do not go to prison. And to demonstrate that even more than the Mueller report, And this is what gets me. I love it. Totally exonerates the president. Even though it says, even Barr said, it does not exonerate the president. Totally clears the president. Thank you. Very legal, very cool. Yeah. So, when we look at other rich people that are not necessarily politicians, we look at how, Jussie Smollett, who was indicted in Chicago for false police report, faking a hate crime, faking an attack, indicted. Wow. It's pretty rich. And you see what happens with all these USC parents and these rich Hollywood types. Yeah. They're going to get a fine, if anything. They're not going to jail. They're not going to prison like you and I would. That's just not how it works. There are two sets of rules. Yeah, there's always an exception. Says here from the ChicagoTribune.com, in a stunning reversal. What? He was a celebrity. In a stunning reversal, Cook County prosecutors abruptly dropped all charges in an indictment accusing Smollett of staging the January 29th attack in Streeterville and falsely claiming he was the victim of a hate crime. They claimed they had overwhelming evidence of this. In exchange, prosecutors said Smollett agreed to forfeit the $10,000 he posted for his bond and perform community service. Let's explain something here for those who may not be aware of this. Okay? $10,000 to a multi-millionaire is like $100 to you and I, the regular people. Okay? It's nothing. It's literally like 0.5% of what he makes a day. I mean, this is a joke. The purported deal appeared to be hastily arranged. Smollett only completed the community service Monday and apparently was not put in writing. While prosecutors claim to have overwhelming evidence, the deal did not require Smollett to admit he did anything wrong. What's more, Smollett's lawyers have vehemently disputed there was an agreement at all, and now the entire court file has been sealed at the defense's request. Yep. That's why they tend to call Chicago one of the most corrupt city in the most corrupt state in the United States. That's just the top. But here it's different because the mayor and the police seem to be outraged at this. As if the police don't exercise, and the mayor, was it Rahm Emanuel, as if they don't exercise the same double standard that these prosecutors did. From top to bottom, this is not on the level, Emanuel told reporters. Where's the accountability in the system? Wow. That, does that qualify for the Irony Award of the Year? Rahm Emanuel, mayor of Chicago, calling it a whitewash of justice and asking, where's the accountability in the system? Really? And I bet if you were investigated and you were actually indicted, you wouldn't see the inside of a jail either. Wow, this is the pot calling the kettle black, so that, you know, and no, that's not a racist thing. Unbelievable. What's unbelievable is how brazen and in your face the double standard is, and how these politicians, he said this to reporters. Nothing is there about a follow-up. Like, wait a minute. This city government is one of the worst offenders of this double standard. And you have the audacity that when one of yours is looked at and charged, when if yours does something, how many cops have raped people in their custody, including minors, and got away with no jail time? None. If they did the same harsh standard that they apply to us in a traffic case, these bastards would be spending decades in prison, as they should. Go into a traffic court, ask a question the judge doesn't like, you can go to jail for 90 days. These people, nothing. Nothing. There is documented proof, for example, that Captain Bonespur, okay, and there are witnesses and documentary proof of this. It's been testified to. He falsified bank applications at Deutsche Bank. Falsified them. He's never going to see a day in jail in his life. And I'm going to be doing an entire video dedicated to just examples like this. And it's something that I could do on the show every single time because there'll be 2, 3, 4, 10 examples a week and report on that. So if you know of examples of like this where the rich have gotten away with heinous crimes. Hey, the DuPont heir raped his daughter. Okay, I believe she was under the age of 6. Not a day in prison. And that's why we work, and I work to expose the system as criminal. It cannot be reformed. You have to get rid of the ruling class. It cannot be, and the biggest thing that we have is of course getting to where it's voluntary, where the support is not the barrel of a gun. That will gut and you know what's the word? That will castrate the ruling class. But again, if you have any examples, and there are a lot, email them to me or Skype in to me, and so I can then research that and then put them into the video, because anybody arguing that we should have a ruling class should have to explain this double standard, and it is not an isolated incident, not by a long shot. For a politician to go, for a judge to go to jail, Ken Anderson, what a piece of garbage. Put a man in prison for 25 years knowing he was innocent. Knowing he was innocent. Spent less than 10 days in jail, and I'm pretty sure he had a sweetheart deal, just like that Jeffrey Epstein, Clinton's buddy, Prince Edward's buddy, or Andrew, and Captain Bonespur, the Cheeto himself, Donald J. Trump. Only had to spend the night there. I'm guessing that this Ken Anderson didn't do any hard jail time. I can't prove that. That's speculation. Can't prove it, but hey, who thinks a judge is going to be doing hard time like you and I would? Anyway, let us get to the call right here. All right, let's see what we got. Speaking of Chicago, we've got Balaki back.
Yeah, what's going on?
Oh.
Can you hear me all right?
Yeah, I can hear you.
All right, cool. Yeah, I'm back. I am back. Yeah, I had that hearing a couple hours ago on my motion to dismiss for prosecutorial misconduct. It went pretty interestingly. I think the prosecutor said all of probably 2 words today, and we were in there for probably a good 20 minutes. But that kind of tells you the story.
Let me take a guess that the 2 words were "it's frivolous." So it's frivolous.
Not quite, but yeah, I mean, to that effect, he didn't say anything of any value. It was mainly the whole 20 minutes was basically the judge having to pause, especially in the beginning, having to pause and construct some sort of type of lie, really, but some sort of plausible explanation of it. But specifically, one of the things that he said not only just once, but he said twice. You know, the prosecution is not required to present any evidence until trial. Then it becomes a trial issue. You know, I've asked him this twice, I believe, or maybe it was in a different case, but I definitely asked him today. I said, so is it your position that the prosecution can just surprise me at trial, with whatever that they plan to use against me. And his response to that, was like, no, they're not surprising you. But whatever things that they plan on using, and you should, heretofore today, you should have a pretty good sense of what that is. Him referring to the police reports or the video or what have you, or the ticket itself. He's referring to those things that they could be evidence, but they wouldn't be evidence until trial, until someone gives sworn testimony over them. And of course, I objected. We went on, but
so it kind of looks like he's trying to make a distinction between facts that have to be alleged, and provided during the pretrial, and evidence, which I think is a real douche move. You're talking about the evidence, which are the facts that prove the prosecution's case that they plan to use against you, and that the pretrial is that it's called. It reminds me of one of my favorite movies, one of the best lines. It's called disclosure, you dickhead. Did they not teach you that either in law school? It's called disclosure. Brady material. Even when they say that in real minor traffic cases, okay, when the rules are that they don't have to provide pretrial discovery until right before the trial. Like New York is like that. That does not excuse them from the Brady material. So I guess one of the other question would be like, so is it your position the prosecution has no supporting facts to even meet a prima facie burden on jurisdiction? That's where we stand right now, right? Because if he does have such facts, then you're supposed to disclose it now. I'm not saying it. He has to prove it beyond a reasonable doubt, which is what they may be trying to do. That's kind of a dick move that they like to do. Well, you're misunderstanding. The prosecution doesn't have to prove it beyond a reasonable doubt right now. That's for trial. No one's asking for that. We just want disclosure. What is it? If you're under this is why I've said to him, if you're under the impression that there's evidence of jurisdiction, that there's sufficient facts to prove jurisdiction over me, tell me what they are in the record because I'm not seeing it. And that's not asking for legal advice. And anyone who says that is being a dick. That is not legal advice. And sometimes you get tired, Blake, of hearing these stupid excuses from the same few people. Asking for the evidence being used against you is asking for legal advice. Really? So you're telling me that when I put in a request for discovery for the prosecution to tell me what evidance he's using, that's asking the prosecutor for legal advice? Okay, I'm sorry. You're the one who had the hearing. So, what did the prosecutor actually say? Was there any, if you're saying they said only a few words, they didn't actually say anything regarding the facts, to overcome the motion, or any facts to show that they're not arguing without evidence?
Correct. I at one point I prompted the prosecutor to restate his position, just clarify his position. Just to clarify, this is at the very beginning of the proceeding. I said, just to clarify where we're left off. And in the prosecutor's response, he says, I just want to clarify, is that it's your position that the laws and Constitution apply to me just because I'm physically in Illinois, to which he affirmed very softly. I don't know why he didn't really want to admit that, but he did admit it in general.
Okay.
And the one thing I wanted to point out, really what we're getting at, my line of questioning, was the fact that, well, is there any evidence that has been presented thus far? To which, judge's response is, they don't need to present evidence right now. And then I asked, well, even if you were to say that the police reports and all other stuff is evidence, the only thing that the prosecutor has pled in his response as evidence is the statute or a reference to this code. So then my line of questioning was centered around trying to confirm that was his position, that yes, that's the only thing I'm relying on is this code, which the judge referred to as, that's the jurisdictional code. It's kind of the standard, establishes jurisdiction. And at one point he made reference to the idea that somehow the jurisdiction, the code or statute itself, on the face of the charging instrument, that establishes jurisdiction. He said that, and I object to that. And I wanted to say objection, that was wrong, but I said objection. I didn't have the standardized, actual, relevance or, facts not evidence, but I was just like objection.
Objection assumes facts, not on the record. Or, it's outside it's not a part of the record. And, I'm glad you got a hearing on it, but it seems to me that, the prosecutor, if he could make his case, would have done it without the judge having to go bend over backwards and do it for him. Does anyone think for a second that the judge was going to help you out with your argument?
Right.
So that's something for any critics, although I haven't noticed we have any critics on this particular live feed. You, from what you're reporting to me, the judge was doing the prosecutor's job and explaining the prosecution's position, instead of the prosecutor doing it. And there was no way that any judge would give us that same courtesy, and not that I'm looking for it. Okay, so all right. So how does this? So the judge just ends it by saying, "But how does he end it?"
Well, so the hearing was technically my motion is dismissed for prosecutorial misconduct,
right?
Arguing without evidence. So he said, "Well, there's nothing in your motion that pleads that or presents that there's a lack of evidence." Or I don't think he even said evidence. But he said there's no. He might say there's no evidence of prosecutorial misconduct within your motion, or something to that effect. There's nothing here that says that proves that there was prosecutorial misconduct. The first time that he mentioned that, he hadn't ruled on it, and it's an objection. I lost my train of thought.
All right, so he's basically trying to apply the same.
I was basically making the point that there's no evidence. I was basically made the point with a couple questions that there's basically been no evidence, and then he came back and just said, denied or whatever, or objected.
So basically, he's taking the same standard that you're trying to hold the prosecutor to, and he's ramming it down your throat.
Right.
That's what they do. That's what they do. They project. It's just like when we had in California with the IRS. They are arguing the correct legal standard. You may not make just conclusory statements. There has to be facts to back up your conclusions. Okay? I'm like, yeah, we agree with that principle. Why aren't you holding the IRS to that? And it's such a blatant double standard. It goes into, this is like a microcosm of what the whole thing, this is what we're talking about. Like when about the rules not applying. If they applied the no evidence rule to the prosecutor, he's saying he's not even required at this time to provide it. He is basically admitting the evidence isn't there, and he doesn't have to present it to you or disclose it to you until trial. So at least he hasn't been, from what it sounds like, he's not foreclosing, and the fact that you have newly discovered evidence. What will happen at trial, if it goes to trial, you will get further evidence of that, because you under cross-examination, you'll ask the police officer, did you determine that just because I was physically in Illinois, the laws applied and gave you jurisdiction? He'll go, yes, I did. And then when you follow that question up and say, oh, well, Mr. Police Officer, hometown hero, when you made that decision, what facts was it based on that just because I'm physically in Illinois, the Constitution applies? What facts did you base it on? They will impeach their own witness. Now you've got hardcore, indisputable proof that of misconduct. He knowingly put a witness on the stand that wasn't competent because he's going to say the witness is incompetent to testify, even though you're only asking for facts. And then you'll be able to go back, because before he gets on the stand, you'll be objecting.
Exactly.
You'll be objecting that there's no proof of personal knowledge. They're going to put him on the stand anyway. There's your misconduct. And then because he won't be able to testify to the facts that led him to believe that the laws apply to you, there is your issue of where he can't prove jurisdiction. Now, you're not going to be like these people and go, I told you he didn't have evidence. I told you at the hearing. You ignored it. Trying to be promoted by old Rahm Emanuel? Okay. Not the best joke, but...
Yeah. So yeah, we actually just scheduled a arraignment. So I mean, I haven't been blood yet, and he scheduled it for over a month from now. So his I guess contention was, it gives you time to work something out with the prosecutor.
So when is the pretrial conference scheduled?
Oh, there's no pretrial conference, but I mean, I guess technically right now, if I wanted to have a pretrial conference, I guess I could. But arraignment is scheduled for the 30th of April.
You haven't had arraignment yet?
No.
Alright, things went a little bit out of order here. You're supposed to file the motion to dismiss with the discovery request, and then but discovery doesn't really start until after the arraignment. So they still have to disclose these things to you. So, but you did file the motion, the request for discovery, right?
Oh, I guess that would have helped. Yeah, so he granted that. He granted, partially, I suppose.
Okay, what did he deny?
But he denied, his presumption, or I guess he was operating under, I'll grant you Brady, meaning prosecution is only required to give you Schmidt, essentially.
Okay.
The Schmidt discovery. So, that's why I say partial, but he wasn't under or it wasn't his position that the prosecution had presented any facts, to support their claim.
Yeah, well, he doesn't have to disclose that until after the arraignment anyway, so, I got some other calls we got to get to before the end of the holy crap. Wow. We'll do the role playing tomorrow, and we can talk about it more. Make sure we get you prepped. So if you do have a pretrial conference, you can you can effectively challenge the prosecution, and then you can use his statements. And then once you get certain statements from him, then you can use that against him when you refile the motion to dismiss for prosecutorial misconduct, because you'll have newly discovered evidence to use against him. And then we'll take it from there.
Yeah, let's talk about it tomorrow, because I like to set something up pre-trial conference so I can talk to him. Actually talk to the prosecutor.
Well, we can talk more about that tomorrow, okay?
Sounds good.
Alright, appreciate the call.
Thanks again.
Yep, we'll talk to you tomorrow, and yes, we are doing the role playing tomorrow at the same time as this show broadcast. We do that on Discord. You get me at Frank Rizzo 3, and then I can get you the link for that. And the role playing is really important. I did some role playing with somebody yesterday, and what it does, not only does it help you learn to effectively defend yourself, how to argue and get people to contradict themselves very quickly, but it also gauges where you are, how effective you are right now. Because it's, with just a few questions, it's going to come out, just a couple minutes if you're prepared to tangle with them. And if you're really nervous and have anxiety with me, they're going to eat your lunch, because I have no power of contempt. I'm not going to start yelling and screaming at you. I'm not the violent one. It's the one we're preparing to stare down. They're the violent ones. So, but doing the role play helps keep that anxiety down, because you're getting used to it. And the more you do it, the easier it is. So maybe we get some more people that are going to challenge these people on their playground, go to city council meetings. Hey, if I hey, you guys operate under the presumption if I'm physically in Mississippi that your laws apply and create obligations and give you jurisdiction and whatnot. Do you have any facts that would prove that that's true? Anyway, let's get to another call from California. Donna from California, welcome back to the show.
Hey, thank you for sending those templates.
You have questions regarding that?
Which ones do you file before your arraignment date?
Okay, this is in the instructions, but I'm going to cover it again. Yeah. If you're in California, you are going to file 3 of the documents. You're going to file the demur, which is basically a motion to dismiss that they have not set forth sufficient facts to, that a public offense was committed. The second one is the request for judicial notice, which we're trying to make it more difficult for the judge to just be a rubber stamp and say denied. Because part of what's in there is that the California court system, like the rest of the United States court system, is an adversarial system. Then you also have the discovery request. What about the what about the judicial request? Judicial notice request?
So the judicial notice is forcing them to look at the law, and then the request for discovery and Brady request is show me the evidence that you have.
Yes.
Right?
Basically, that's
right.
It. Yep. The discovery request is show me the evidence you plan to use against me, the facts you plan to use against me to prove that the laws apply and I violated them, and the names of the witnesses with personal first-hand knowledge of that.
Right. And when I went to the courthouse, they say that a pro tem judge is going to be the one looking at it at the arraignment. So a pro temp doesn't have is not a judge whatsoever, right?
They're a temporary judge. So I have a friend of mine who is a pro tem here in Maricopa County. And so he goes so if a judge is sick, well, let's say a judge has cancer, which we can hope, then he fills in for him. So he'll travel from Mesa to Glendale and whatnot. So he'll go to Phoenix. He goes where he's needed. He is a sworn judge, whatever that, for whatever good that is. He has an oath of office, and he is technically a judge.
I asked for the oath of office and the bond at the courthouse, and they said they don't have it and they don't know where it is.
Okay, now I know you've been on the show a few times, and I have discussed explicitly in the last few shows there is no bond. Period. They self-insure.
Okay.
The oath of office, the oath of office is not kept at the clerk's office, though. The oath of office is usually depending on where they are. They're with the Secretary of State, or it's with personnel, or with the county clerk or the city clerk. It is not held. So if you're going to the clerk of the court, you're at the wrong building. I don't know, unless you're trying to find the oath of office and he doesn't have one, that's the only way the oath of office is going to help you. And the other thing is if he had, like I had one, Harold Reeb. Wow, I haven't heard that name. That's a name I haven't heard in a while. Harold Reeb, I was able to get the only copy of an oath of office he had on file with the city clerk. And this is in Mesa. He was with the Mesa City Court. He was the presiding judge. His oath of office was from, and this is like 1997. His oath of office was from 1967. He was a career prosecutor. I presented that and almost went to jail. So, I said, you're not a judge or a prosecutor. So in that vein, it may be helpful to have it, but yeah, go to the city clerk.
I was just curious if the judge had one or not. That's all I want to know. But another thing is before I lose my train of thought here, is they sent me a form, and it says read both sides of this form, and it tells you that you could either pay the fine, send the fine. I mean, it's all talks about how you can pay it.
Yep.
And then the other side says if you want a trial, you have to sign this form and send it in that you want a trial and then you're going to plead guilty. I don't want to sign this son of a bitch.
You don't, well, you see, this is what they call in basic logic a false choice. Okay? They deliberately leave out that you can do what you're doing, a demur. Okay?
Yeah.
That is done
right.
deliberately. And some may say, well, they're not required to give you legal advice, jackass. Well, then why are they putting in there that you can ask for a trial? Why are they putting in there that you can plead, guilty? So if the options are guilty, not guilty, no contest, or demur, why don't they say that? Why do they leave number 4 out? Why do they because it's done deliberately, because these people are dishonest. They don't want you to know that. Now pretty much every lawyer does.
I'm not gonna sign this thing and send it back.
There's no reason to. That's not, you're taking door number 4. You are going to do what is obviously allowed under section 1004 of their own penal code, and you're filing a demur.
Well, another thing is say I file all these things before the end of the week, which I want to be filed in March, not April. And the arraignment is the 29th of April, which is a month away, a little over a month away.
Yeah.
Can I hope that when they get these in before April, which gives them more than 30 days to look at all this stuff, is it possible for them to look at all 3 of these things and say, you know what, this really ain't worth it. Let's send her a dismissal notice. And then, I won't have to go in.
That has
for the
happened.
Arraignment.
That has happened. So it's possible. There's absolutely no way to know for sure.
If it doesn't happen, then, say that I go to a trial, right?
Well, you'd go to the arraignment first on the 29th.
Yeah, but say that doesn't happen and I go to the arraignment. Okay, say I go to the arraignment and they look at all this stuff and I say I'm not ready to proceed because I have a demur filed and it has to be looked into, right?
Right.
Look into the matter, right?
Yeah.
And say that if they try to play games with me and question, back and forth, bullshit that I don't want to do, I could just say I'm not here to state any legal advice. I've already filed my papers. My papers speak for myself. I need to handle the matter today.
Okay. Well, first of all, I don't want to get a strike and have my YouTube channel stretched, so we're gonna have to watch the language.
Okay.
I would never go in and say that the demur speaks for itself. I would always question them. And, I'm fully aware that there are keyboard warriors that say you can't ask a judge questions. Well, I have news for them. I got news for you, Raymond. I have audio of yet another judge answering questions. So the idea that you can't is stupid. The idea that you shouldn't is stupid. Use what is in your means to defend yourself against these, and it is definitely an effective way. I've proven that. So, what I would do is I would ask questions. Has the prosecutor, because there's probably not going to be a prosecutor there. So you ask the questions. Does the prosecution have sufficient facts to overcome the motion? And then you can get into a dialogue on that depending on what the judge actually says. Because that's the only way to overcome the demur is that they do have sufficient facts to set forth a public offense. But just alleging the laws apply and you violated them is not enough. Alleging the laws apply and you violated them and they show facts that show that you may have violated the law, not sufficient because they're assuming the most important part of this code violation, and that is that the code applies. Now, again, I don't have the time to get into, we're pretty much out of time.
Right.
Because I've discussed this at length, and we could discuss it tomorrow. I would recommend if you get a script, you join us on the role play. Even if you don't have the script yet, join us on the role play tomorrow, or at least listen to some of the role plays. Same time as that this show broadcasts, 3 to 4 Pacific time.
All right.
All right, but contact me on Skype at Frank Rizzo 3.
3 o'clock on Skype, right?
Well, before that, contact me on Skype before that so I can get you the link so that you can at least listen in.
All right. Well, thank you much.
Appreciate the call. Donna in California. Yeah, it's, we got to know the basics. This is something I'm going through with someone I'm working with in Mississippi. The basics. We assume that every single thing coming out of the judge's mouth and the prosecutor's mouth and the cop's mouth, if they're politicians or bureaucrats, we assume everything they're saying is a lie, and our job is to get them, through asking questions, to verify that what they're saying is actually true. And the foundation that sets the relevance for everything is that you're in Mississippi or you're in California and the laws apply. That is that sets the relevance for everything else. Because whether you violated a rule or not, it depends on if the rule applies in the first place. Again, critics will say you have to just assume that. Like the law is magical. No, we go based on the facts. Laws are written instruments. Constitutions are written instruments. They're not magical. They're not from some god. They're just written instruments. And we have to take it from the position of a skeptic. That unless it's proven, it's not true. Remember, go through your logical fallacies, appeals to tradition, appeals to authority. Just because a lawyer said it, that doesn't make it true. That doesn't make anything true any more than if I say it. Lawyers are not some exalted people. Lawyers don't hold any deep hidden knowledge that is all being hidden from everybody. Learn your logical fallacies. Something is not true just because I say it or somebody else says it. And not because someone, puts on a robe on. Ritual doesn't make it true. I appreciate everyone tuning in today. We'll keep talking about the basics, teaching people how to effectively defend themselves in court, and keep adding to the success stories. But I thank everyone for tuning in to this episode. It's the 104th episode of The Big Show, live from the Fortified Compound in Mesa, Arizona. And I appreciate every one of you for tuning in. If you want to help support The Big Show, it is much appreciated. Marc Stevens at cells.com and markstevens.net. And hey, till next time. Solid.